is a partner appeal in a matter of government psychology and others of Elshie district
Mr. Raphael, I was a bit too generous yesterday. We will sit tomorrow afternoon if we need to, but we will have to have a hard stop at 3:30 because there are other places some of us will need to be shortly after that. We want to have a little time to discuss the case. So if between you could tailor your submissions to achieve that object, if we do need all that time.
My lords, my lady, I'm obliged. We were calculating we might have up to 4:15. I think we can still do it, not least because Mr. Musa doesn't need to do a statistical teaching. So we should be able to make that work.
All right, well that gives you an extra hour and a half over the estimate, so we'll have to make do with that, I'm afraid.
I'm obliged. So before I return to the case stall, it's just worth touching on the nature of the economic theory predictions. So you understand what actually that means to predict something as a matter of economic theory. What they are is logical arguments which derive mathematical models based on abstract assumptions identifying rational incentives. That is what they are. So when LG say that economic theory predicts that a firm will tend to pass on in certain situations, it is saying that if you apply a model of a rational maximizer under certain assumptions, then you can infer that rationally there would be an incentive to pass on. And those assumptions are considerable. They include rationality, efficiency, perfect information often, and so on. So these models don't tell you how an actual firm actually acts. They ignore possible countervailing factors. And likewise, the models that say, well, using those rational predictions as to incentives, you can assume 50% pass on or 100% pass on as the likely result. They're based on the same assumptions. They're just mathematics applied to the logic of the rational incentives the models build in. So when an economist says my model says they'll be passed on at a certain level, it's simply saying that's something you can extrapolate from certain rational assumptions. What these aren't is empirical models as to what actually happens in any particular situation with statistical surveys. And there's a divide between that sort of approach and more practical economic literature, which looks at real markets and identifies situations where the facts aren't consistent with the assumptions and where pass-on doesn't happen. And classic examples of that are companies aiming for market share, not fixed margins, and therefore absorbing cost increases. That's a classical countervailing possibility. Or psychological pricing, which I'll come back to. Or simple inefficiency, accident, applying rules of thumb rather than the ideal models the economist says you should use. And that is why the theoretical models of economic theory do not support an inference that supports the legal test for a case of pass-on. They certainly cannot satisfy a direct and proximate causal link for the simple reason that you don't know in a particular case whether the facts are consistent with the assumptions of the rational models. And you don't know in a particular case from the assumptions whether this is a case where the countervailing factors might apply. So simply the models, though informative and interesting, do not support an inference of a direct and proximate causal link. And that...
Sorry, can I just...
Yes.
So, the way that I understood the authorities to go yesterday on a brief review was that economic theory alone doesn't overcome the evidential burden.
Yes.
You say, I think you probably accept that and say there needs to be something on the facts of the case,
Yes.
which would overcome the evidential burden, at least at the outset, of the court actually having to grapple with the question, because that's what the evidential burden is. It's just enough to put the thing in front of the court. But once you get over that on the facts of the case, then economic incentives, rationales and the like can presumably come back into play.
You can consider them,
Yeah.
but again, you must always be considering The test is a direct and proximate causal link. And Westinghouse says it's got to arise out of the transaction to be mitigation. And so when you consider the force you give, if any, to these models, it's got to be in the context of the tests you have to satisfy. That's crucial. And also the simple fact that in a particular case, the model assumptions may not work at all if there's a countervailing factor identified. And that's what's underpinning the case law. Now, you've seen in Stellantis that they approved bits of Royal Mail amendments. They'll help to look at that case as well. And that's in Authorities Bundle 1, tab 15 of the Authorities Bundle. Should be 3 in your hard copy bundles. Authorities Bundle 3, tab 15. And I start at page 9, Authorities at page 984, and I start at paragraph 32, which is on page 997. So paragraph 33. The effect of a pleaded mitigation defence in general terms is to cast a significant burden on the follow-on claimant. And then it discusses Sainsbury's.
32 at 997.
Yes, page 997.
998 in the PDF.
Ah, I'm sorry, it's that difference.
Sorry.
And then you note this, there's a real risk in our view of infringement of the principle of effectiveness unless there is some basis other than pure theory for believing the defence mitigation has some factual basis for it, and so it can properly be pleaded. That's at 33, 34. Then moving on to 34, they discuss the situation that might happen in a normal commercial case, where of course one never would contemplate the idea that a contract claim for damages is defeated because rationally you assume that people may pass on costs down the chain. And they say that therefore a claimant such as Royal Mail or BT in a damage claim under competition law should not be more vulnerable than a claimant in a domestic commercial claim to defence mitigation. Then at 35, accordingly it seems to us it cannot be enough for a defendant to plead that a claimant's business costs as a whole were not increased, or that as part of its ordinary financial operations and budgetary control processes, its overall expenses were balanced against sales so that profits not reduced. There must be something more to create a proximate causal link between the overcharge and a reduction in other input costs. So it's not just a question of initial burden, it's about the end result you're testing. This can be inferred from the Supreme Court's citation from Westinghouse, and then you see the point about the claimant has taken action arising out of the transaction. 36. Now, they're approaching this context of amendments, but of course the same point applies to your eventual decision at trial. Mutatis mutandis. We therefore consider that for a defendant, this is 36, to be permitted to raise a plea of mitigation this way in general terms, there must be something more than broad economic or business theory to support a reasonable inference that the claimant would in a particular case have sought to mitigate its loss, and that the steps taken by it were triggered by, or at least causally connected to, the overcharge in a direct manner required by the British Westinghouse case.
I mean, you can't take that literally in the sense that, by definition, the claimant will not have known that there was an unlawful cartel.
You absolutely can take it literally.
So how does that work? Because the claimant, by a fortiori, will not know that there is an unlawful cartel operating. How could they possibly, therefore, if that's what that means, the test could never be satisfied?
Well, I'll show you later where the significance of the overcharge being unknown is highly relevant in the context of the test of direct and proximate causal link. That's exactly what the case law says.
Surely all that the claimant could sensibly have to know was that there was a particular price that they were being charged, or an increase in price, and how they would respond to the increase in price. But you can't expect the claimant to know that there is, quotes, an overcharge in the sense of being a charge referable to an unlawful cartel, because by definition, nobody knew that there was an unlawful cartel.
I'm not saying that knowledge is a necessary condition, but I'll show you the case law saying it's very important. I'll show you that in a moment. Now, there is this difference.
Well, it's very important that a claimant should know that there's an unlawful cartel and they're being overcharged as a consequence.
The point being that you have general changes, you've got supply increases coming into you, they may not reflect the whole market, you don't know. Whereas if you know it's an overcharge, that would give you an extra reason potentially to pass on. That's what the case law says. I'll show you that. It's probably more convenient to come back to the point where I show you exactly why that's so. So then, and just to note, 36, that applies not just to cost reduction, it also applies just as much to price pass on. Then 41, and I'm not going to deal with the particular facts of the case, but then you see this. There is therefore no factual support identified by DAF in these cases. The application of the general economic theory in a direct and closely linked manner meets the British Westinghouse test of mitigation as a matter of law. That's what I want to pick up there. Then moving on to 42. In our judgment, therefore, before a purely general plea of mitigation through business cost reduction process can be pleaded in the way DAF's petition to do, there must be something identifiable in the facts of the particular case that give rise to a prima facie inference that there may well be a direct causal link between the overcharge alleged and the prices paid by the claimant for other supplies that reduce the amount of loss resulting from the overcharge. 43, we therefore hold it's not sufficient for a defendant's petition of DAF to plead defence of mitigation on the basis of broad economic theory and nothing more, where the effect of that would be to place a heavy onus on claim to disclose and explain its financial procedure and operations. Well, that's what I want to take from that case. Just for your note, those two paragraphs, 42 and 43, are approved in Stellantis, paragraph 70. Now, the principles that a direct and proximate causal link is required and issues like knowledge of the overcharge are then picked up in the CAT's main decision at trial in Royal Mail, which is in tab 19 of the Bundle of Authorities, in volume 3, starting at page 1073 or 1074, I hope, in the electronic. And I'll pick matters up at paragraph 183.
So which paragraph is Stellantis?
70.
70.
70, yes.
Really?
I see, I may just check I haven't got that wrong. If we go to Stellantis, paragraph, yes, it's 70 picks up 42, 71 picks up.
Sorry, which Stellantis authority?
The Stellantis tab 16. So we're talking 1027 to 1028. This is the Court of Appeal in Stellantis, not related trial. 1028, 1027, one of those two pages will be paragraph 70 of the Court of Appeal in Stellantis. 1028, it may be in your PDF.
No.
Sorry.
There you see they pick up and approve 42 of Royal Mail amendments, and at 71 they pick up and approve para 43 of Royal Mail amendments. So, coming back to Royal Mail, tab 19, starting at 1074, I'm going to look at paragraph 183 of the judgment. That we can probably move on more quickly. Let's start with 183. Just to pick up at 191. There's a summary of the Supreme Court in Sainsbury's. I'm just taking the point in the quoted passage at 205. The Supreme Court distinguishes two kinds of pass-on. Option 3 is cost reduction. That's in the middle of the quoted paragraph. The merchant can seek to reduce its costs. Option 4 is the merchant can pass on the cost by increasing the prices which it charges. The Supreme Court's identifying those two options. So I want to pick that up. And then if you move on then to 195, we're concerned in this case with category 4. So they're concerned here in Royal Mail Main with price pass on. And there's no dispute this is a species of pass on. Then there's a discussion of Royal Mail amendments, which we don't need to go through again. And we can move on to page 2, paragraph 200.
Can you give me the page?
Which is at 1164.
Yeah.
Now, you see there, it's clear the Supreme Court was treating categories 3 and 4 as having the same effect. Having opened the door to claims of pass on category 3, defendants sought to produce in general terms their defences, and that then led to the amendment decision you've seen, which is then discussed at 201 onwards, and they take the same view as the CAT on the amendments. And then you see the summary of Stellantis at 205. And then if we pick up 206, you see a quote from Stellantis: as to relevance of knowledge of the overcharge, it was plainly relevant in the Sainsbury's case. The MIF was a known thing. The issue of MIF passed the generally in line industry for many years. At the end, all of this was clearly relevant to the burden facing a defendant in this sector seeking to raise a realistic case of mitigation. The MIF was a systematic and troublesome cost that any major retailer would never have had to confront. The facts therefore contrast with those of a typical secret price fixing cartel. 206. Then we move on to 210, where they're summarising the Supreme Court, and you see the Supreme Court in 215 relied on British Westinghouse, a contract case. Then we see this quote from Westinghouse. It's the last sentence of the Supreme Court that's surprising, but the question of legal causation is straightforward in the context of a retail business in which the merchant seeks to cover its costs in its annual or other regular budgeting. That's a note distinction between legal causation and factual causation. What the Supreme Court seems to be saying is there's no live issue of legal causation in relation to any business where the pass-on is either 3 or 4. The only issue is a factual one, and that is whether the merchant did actually recover its costs by reducing other costs or increasing its prices. That's 210. Then we move on to 215, where they discuss this little surprising sentence. In our view, the sentence in the Supreme Court's judgment has been taken out of context, and needs to be read with what came before and after. The Supreme Court, after a quote from Westinghouse, said there's a question of legal or proximate causation that arises in relation to pass on. The rest of the paragraph seeks to explain how that question is resolved. It's not entirely clear what's meant by legal causation, and the Supreme Court does not use the phrase factual causation as a contrast. Rather, it said that the relevant question is a factual question, and then proceeded to define that factual question. What the Supreme Court does not do is set out the legal test for causation. Then Stellantis. As was said in NTN Stellantis, this is 216, the defendant must demonstrate a legal and proximate causal connection from the overcharge and the act of mitigation, or as the CAT said in Royal Mail, there must be a direct causal link between the overcharge and in the Category 3 case, the reduction of the cost of other suppliers. It's insufficient, it was submitted by Mr. Beard KC, merely to allege that the claimants seek to recover their costs. We do not therefore think the Supreme Court was suggesting otherwise in saying that legal causation is straightforward in that case. It's still necessary for the defendant to prove a sufficient causal connection on the facts to satisfy the legal test for causation. Then 219, we're on 1169, we're concerned with the Category 4 case, which appears to be more recognisable case of pass-on, more recognisable than the cost reduction idea. Because in this case, the cost overcharge has a clear possibility to affect the buyer's incentives when it comes to decide how to set prices for downstream outputs that rely on the input. How to set prices for downstream outputs that rely on the input that's subject to the overcharge. But as categories 3 and 4 were both dealt with together in the same way in Sainsbury's, we would expect the same test to be applicable. Merely because a firm seeks to recover its costs and make a profit cannot be sufficient to prove that the overcharge has been transferred to its customers. So that's the economic theory point. Then 220, we agree with the CAT in Royal Mail and DAF. There are two particular factors which in our view are applicable in both category 3 and 4 cases that are relevant to whether a causative connection can be established in the overcharge and increasing prices. In 42, the CAT referred to 1, the claimant's knowledge of the nature and amount of the overcharge such that they would seek to address it. That's the point I was making to you, my lord. And 2, the size of the overcharge is a proportion of the claimant's relative expenditure and or price cost margin. In 44, the CAT compared this case with Sainsbury's, where there was both knowledge of the MIF, as a distinct thing that is, and it was a significant cost, and held that much more of a causative connection, even there, would need to be shown than merely the overcharge being taken into account in the claimant's business planning. Both factors were endorsed by the Court of Appeal in NTN and Stellantis. Mr. Beard case, he submitted that neither knowledge nor size was necessary to prove a pass-on. He went further, just if they were, that may render it impossible for customers to claim their losses, and it would thereby infringe the principle of effectiveness. 222, we agree these are not necessary requirements, but if they're present, the defendant would be far more likely to be able to prove that the defendant was seeking to address the overcharge by taking mitigation that it did.
Is that right? Is that that if you know, then you are more likely to be able to prove, or is it more that if you know there is an overcharge, you are likely to have documents or other evidence you can give which will address how you dealt with that fact?
We would say both, my lord, because imagine you have the vast possibility of things that affect the firm's pricing decisions. What's happening on a particular day, how it perceives the market, how its overall cost position may be trending, 1,001 things. If into that price decision there comes a concrete, distinct, significant chunk of cost, which is clearly the overcharge cost, then the possibility of establishing a direct and causative link is easier. But if you have, in the context of all these factors, just some imperceptible rise, which is a tiny percentage of some other cost, which nobody has a basis to focus on as something linked to anything specific, still less an overcharge, then it's much less likely that there can be proof of direct and causative link. And that's what the CAT is saying. 223. Accordingly, we consider that DAF must prove there was a direct approximate causative link to the overcharge and any increase in price by the claimants. That means there must be something more than reliance on the usual planning and budgeting process in which the overcharge was inputted and at some point prices increased. We think there's substance to the point made in Sainsbury's against MasterCard as the identification of persons to whom the overcharge has been passed as being a relative factor in the strength of the causative connection. So that's 223. Then when you turn to the CAT's decision, I'm not going to take too much out of the details of the case for obvious reasons, but nevertheless it's instructive aspect of how they end up deciding. And they reject the claim of pass on in that case. And then if you turn to paragraph 508, we and the experts agree that economic theory supports the plausibility that a complement's effect might exist. That's a form of pass on there. However, this is 1232. However, plausibility does not prove it actually happened. The theory needs to be tested against reality and the available evidence to show whether there was such an effect. That was actually upstream pass on, so you weren't applying directly the test of causative link there. Then if we go to 572, go to 550, we set out above our conclusion as to law. We've held that for the purpose of legal causation, the number of relevant factors taken into account, none of them being necessary factors, all of which have to be weighed in the balance, decided if there's a requisite degree of proximity to establish a direct causative link. Those facts include the following. One is knowledge of the overcharge, or the specific increase in the cost in question. 2, the relative size of the overcharge against the claimant's overall cost and revenue. 3, the relationship between the overcharge and the product. And 4, whether there are identifiable claims by identifiable purchasers from the claimants in respect of the losses. 551, there's no dispute about knowledge. Neither the claimant knew anything about the infringement of the overcharge at the time, nor were they aware of any particular increase in their truck costs. Therefore, they could not be said to react to the imposition of the overcharge by increasing their prices. they could not be said to be specifically seeking to address the cost increase.
Mr. Raphael, can I just remind you to give us page numbers? I have got it, but we haven't got post-it notes to take us from one.
I'm very sorry, my lady. 1240, I hope. Then 552, it's also accepted that the size of the overcharge was for both claimants tiny relative to their overall costs and revenues. DAF says that size is irrelevant. Size is also linked to knowledge that the larger a cost increase is, the more likely it is to be noticed and therefore specifically addressed. But the claimant's main point is their price is not fine-tuned enough to be able to conclude they are actually higher as a result of the overcharge. Then we move on to 572. As we've already said, in relation to 4 factors identified, this is 1243. As we've already said, in relation to 4 factors identified in 550 above, none of them present in this case. The absence of knowledge, together with the tiny size of the overcharge, mean there's obviously no specific decision by the claimant to increase prices in response to increasing costs. Nor is there any direct association between truck costs and products sold by the claimant. And even if it can be shown there was an increase in prices and an increase in costs, it'll be impossible to identify which prices in relation to which specific products actually increase because of the overcharge. Therefore, we find difficult to see how there can be sufficiently identifiable purchasing the claimants who can make a claim in respect to the overcharge, or to whom, as we said, the loss suffered by the claimants has been transferred. 573, in circumstances, we do not think that DAF can satisfy the legal test for causation, which requires the overcharge to be a direct and proximate cause of the increase in specific prices. Even if, as a matter of forensic accountancy, DAF is able to show the minuscule overcharge to be traced to the series of internal steps, the absence of the 4 factors means the overcharge is too remote for the downstream prices. While the 4 factors are not so decisive or necessary, we think in the situation where none are present, the evidence of factual causation needs to be that much stronger so that the requisite proximity can be addressed. And that's what I want to take from Royal Mail. And then the CAT's decision is adopted by this court in Royal Mail Court of Appeal at tab 21, which I believe is in volume 4 of the Bundle of Authorities physically, starting at page 1321. And this is at paragraphs 149 of the Court of Appeal's judgment, page 1372. This is Sir Julian Flo's Chancellor, Lord Justice New, Lord Justice Green. 139. In my judgment, Mr. Ward Casey's description of DAF's case on SPO, that's supply pass on, as strikingly ambitious is entirely apt. As Mr. Ward Casey pointed out, given the level of overcharge defined by the CAT of 5%, it was no more than 0.025% of Royal Mail's revenues on any of your tiny amount. The idea this tiny amount could not be traced to the price that claimant's individual products. It's then possible to establish that it caused a price increase. It seems to me to be completely unreal. Then moving on to 151, in terms of factual causation, DAF could only succeed if it could establish the prices charged were higher because of the overcharge. In other words, if it could establish, and the burden proofs on DAF, the overcharge being passed on to its customers. The CAT was unanimous as to that requirement of 223, and you see the quote of the direct approximate causal link requirement. I agree with Mr. Ward Casey, the CAT was applying the correct legal test, as recently stated by this court in Stellantis. 152, in seeking to identify how DAF might prove that a direct causal link to the overcharge and the increase in prices charged, the CAT set out a number of non-exhaustive, potentially relevant factors. The first 2 factors, knowledge and size, were the ones identified by the CAT in its May 2021 judgment. In the case involving MIFs, the overcharge in the form of the MIF is transparent and known to the merchant. That's the credit card cases where we had a merchant interchange fee, which was very public. So that it can seek to address that overcharge, for example, by passing on to customers. In contrast, overcharge as a consequence of the secret cartel was by definition not known to the claimants, so they were not in a position to address it. This was not suited for the CAT. And then they refer to the 4th factor of identifiable claims at 153. 154, the CAT concluded that none of the 4 factors were present in this case, and conclusion which was not challenged on appeal. Mr. Beard Casey did submit the majority being wrong to conclude at 573 that we think that in a situation none of the 4 factors are present, the evidence of factual causation needs to be that much stronger so the requisite proximity can be established. In my submission, that submission is misconceived. In circumstances with none of the 4 factors which might establish the requisite degree of proximity to establish a direct causal link between the overcharge and the prices charged by claimants at present, it's both logical and common sense to conclude there would need to be some other evidence of factual causation to establish that requisite degree of proximity. Just to stress, it's not enough just to have a bit of evidence to get you into the game and then theory solves the answer. That would be entirely wrong. You have to prove a direct and proximate causal link. And the final authority to look at is Stellantis and Autoliv, which is in volume 22 of the authority bundle, in volume 4 physically, starting at page 1382, electronic. And if I could ask you to go to paragraphs 277 to 279, starting at 1480 physical, 1481 electronic. And this is the cat in Stellantis.
I'm sorry, you'll have to give me the... Can you give me the...
1481 electronic.
1481.
While there was some evidence that when margins declined precipitately or were far from target, they would seek to raise prices, the tribunal heard no evidence suggest that companies would raise their prices in response to a relatively small increase in manufacturing costs. In our case, of course, we've shown in our skeleton that the low level of the overcharge as a proportion of package prices produces a tiny figure, about 1%.
So the stronger your case on the previous ground is, the weaker this submission becomes.
It does, though I don't think I've done the mathematics on that. We would say you still end up with a very low figure, but certainly on viewing this as an independent ground of appeal, which I'm doing for present purposes, that point runs in its exactly calculated.
Mm-hmm.
The tribunal heard no evidence to suggest that companies would raise their prices in response to a relatively small increase in direct manufacturing costs. The evidence does not establish that profitability is finely managed, such that adjustments are made to small variations in component costs. The overcharge is with literary concerns and was raised between 10.8% and 22% in the main period. The cost of the various components is relatively small. Autoliv in its cross-examination puts the case broadly, suggesting that costs in the generality will be passed on to the dealer. It was understood that raising prices would be expected to have an impact on volume. The costs, which are not industry-wide, and not automatically passed on to customers. There is not a direct proximate causal link between a small price increase and prices charged to dealers or supportive dealers in other forms. Well, that's sufficient from Autoliv. So that's the law, my lords, my lady. Then, turning to some of the real-world factors that can counterbalance price pass-on. First is psychological pricing. The point is that companies often price at attractive points like $5.99, and in that context, even if there was otherwise an incentive to pass on £5, you might lose a lot of sales by selling at $6.04. It's a well-known phenomenon because it's a less attractive situation. The judge accepted that, 231 of his judgment. He relied on Dr. van der Laan's evidence, referring to the literature Dr. van der Laan cites, and none of that was challenged in cross-examination. Point also clearly made, and to just give you the references in case you wish to dig into the evidence that he adopted, it's in Van der Laan 4, Supplemental 1, tab 10, page 521, and it's at paragraphs 1.2.3 to 1.2.21.
So economic theory is all right when Dr. van der Laan is to be.
This was not theory. This was what I gave you the example of the practical identification of contrary factors. So in the real world, these are things that happen. And that's what the judge accepts at 231. Points also clearly made in the Commission's pass-on guide.
So 231 of the judgment.
Yes.
It's sort of a mixed bag, isn't it? I mean, the judge sort of accepts it in principle, but then has a number of reasons why it doesn't psychological pricing doesn't actually
Yeah.
have potential effect in this case. I mean, are you saying that you accept 231 in its
No.
entirety? Or?
What he does, I'll come to that in a moment, he accepts it as something that can operate.
Yeah.
What he doesn't do is then apply the test of direct and proximate causal link.
Well, but this is just one of the factors.
Indeed. But let's imagine you've accepted that psychological pricing can operate, and he accepts as a matter of fact that it's the majority of the cases. Then where is the direct and proximate causal link? He's not shown in any way that there are cases where it doesn't operate, or what's happening in the other cases. He's not shown there's a class of cases.
Hang on, psychological pricing is not a killer for pass on.
Well, let me show you why that's so, very briefly.
I mean, suppose you identify as a claimant that you are faced with an increase of 10 in the cost to you.
Yes.
I mean, you don't know it's due to a cartel, but in fact it is. But anyway, you identify separately you've just been wanged with a £10 rise.
Yes.
You say, okay, we've got to respond to that. Well, we'll have to put our own prices up then. But we probably ought not to put them up beyond £599 because that is a price we want to it sounds better than putting it up to £603. But we will put the prices up to £599. Now, why isn't that?
Your
psychological pricing doesn't kill the pass off
because they're already pricing at $599.
No. I wasn't assuming that.
Well,
I was assuming, let's say, somebody is pricing at $555. Psychological pricing would limit the amount which they would wish to pass on, but it doesn't kill it.
But there you have an assumption that they're not pricing at $599, and that there's absolutely no basis to suggest there's a margin.
No, but what I was putting to you, sorry, I thought your submission to us was that if there is psychological pricing going on, that is fatal to any pass on.
It is fatal to the establishment of a direct and proximate causal link.
That's what I thought you said, yeah. Okay, and I was trying to put to you a case in which there would be a direct and causal link to pass on in part, but you would be limited in the amount because of your...
You can speculate. Yes.
Yeah, but as a matter of law, are you as a matter of law saying if psychological pricing is present in a case, there can, as a matter of law, be no pass on?
No, I'm saying that in a case where there's psychological pricing, which is extensive, and where there's no proof of any situation where it does not apply concretely, there is no direct and proximate causal link, at least to the extent of the psychological pricing. So, if we pick up the Commission's guide at Supplemental Bundle Volume 3, Volume 4, page 1341 or 1340. This is 187, the Commission's Practical Guide, 1340 in the numbers I've got. Another example of how price adjustment costs may affect the degree of passing on, paragraph 187, is related to the existence of so-called psychological pricing costs.
Again, I'm sorry, I've got either the wrong bundle or the wrong page.
Supplemental bundle, not the authorities bundle. 1340.
Sorry.
Volume 4. That is. In many markets, typically retail markets, prices little less than a round number are common. The customers may perceive such prices lower than they actually are. The use of such a pricing strategy make it more likely that the direct purchaser chooses not to pass on overcharge.
Sorry, what page are you reading from?
1340, my lord. In tab 23. In the physical, volume 4 of the supplemental bundle.
Right, thank you very much.
And paragraph
187.
Yep.
The use of such a pricing strategy may make it more likely that the direct purchaser chooses not to pass on an overcharge, as the change in price would lead to a significant drop in the direct purchaser's demand.
Yeah, and just the first sentence of 1787, another example of how price adjustment costs may affect the degree of passing on
Yes.
is related to the existence of psychological pricing. I mean, they don't suggest that the existence of psychological pricing as a matter of law eliminates
No.
passing on. It just may affect it the degree, which is
And
what
it
I was
depends.
putting to you.
And it depends on the size of the overcharge also. Let's imagine you have a £100 increase in your costs. Well, then psychological pricing might not.
Gives you a lot more scope to hit a psychological price point
You might
while accommodating.
go to £699 if you have £100. When you've got your 1% increase, that's when psychological pricing really operates. And you cannot assume they're pricing at £570. The natural position is they'll be charging at a psychological pricing. So,
Well, isn't any number that ends in 9 a psychological price?
yes.
So if 569.
Oh, no, generally we're talking 99s rather than 9s.
Well, but 74s instead of 75s.
Yeah, if they were at 74, but the natural assumption is they aren't. And just so you see, there is a lot of evidence in the judgment they were using psychological pricing, and I'll come back to that.
Psychological pricing could be, well, I'd rather it start with a 7 than an 8. I mean, it's a question of fact and degree, isn't it?
In the context where they need to prove a direct and proximate causal link. If the test...
The mere presence of psychological pricing, I go back to the point I've been bleating on about, I'm sorry, but the mere presence of psychological pricing can't be an absolute defence, it's an absolute ouster of pass on.
If you have an argument for pass on based solely on theory, you can infer people are likely to want to pass on increase in their input costs. If that's your basis, but we know that this firm is affected systematically by psychological pricing, that gives you all sorts of reasons to conclude there'll be many, many cases at the least where there won't be pass on because psychological pricing will constrain. So there is no direct and proximate causal link. Everything I'm saying you is put in the context of direct and proximate causal link arising out of the transaction and proof on them. That's it. That underlines everything I'm saying.
But if we look at 231,
Yes.
Judgment,
Yes.
the judge says that it may have an impact on the timing or degree. It's highly fact sensitive. I think you would agree with that. But he thinks it's a relatively limited impact. He gives some reasons for that,
Yes.
with some of which you're going to go on to quarrel. But he does say it was not universally adopted by the claimants, and I'm not sure you disagree with that. And then says, well, at the end, well, I accept it's a factor I do have to take into account to some extent. And isn't that a judgment which he's entitled to make?
No, because he's not applied the test for direct and proximate causal link. Also, just while we're there, note the end. Firstly, his findings elsewhere, when he says not universal, his findings are extensive and a majority, and he doesn't say it's a bare majority of 51%. I'll come back to that. Then, but also, this paragraph is actually also fatal to his conclusion. Because what
Could you just give us the paragraph where he says extensive and majority, so I can cross-reference in?
It's 201. But just on this paragraph, my lords, there is a... If you look at what he says at the bottom. Secondly, passing on price increases can be achieved in a number of different ways, including altering the specification of the product being offered.
Which?
This is 231.
231.
Yeah. That's his reason there. That is, he's saying he's accepting the possibility of pass on by cost reduction.
Well, that's why I said you were going to quarrel with some of the...
Well, it's not that we quarrel with what he's saying, it's that once he's saying that the pass on he's talking about includes cost reduction as a possibility, i.e. you meet the psychological pricing threshold, you keep the price as it is, you just fiddle around with your costs. Once he accepts that's a possibility, that shows clearly that his reasoning of causality is allowing for both possibilities, and therefore he's not showing a causal link to a price increase. My lords,
I can see extensively in paragraph 201. I can't see a majority.
It's-
Maybe I'm missing.
202, my lord. Extensively in 201 and then a majority in 202.
Thank you very much.
So the final point which he accepts in principle is that low levels of overcharge are less likely to be passed on. It's in judgment 207. At a high level of generality, I accept the position. The lower the contribution made by the LCD panels, the cost of the package being sold, the less likely it was that a cost increase would be passed on. So he accepts the point in principle. It's also a point made in the judgments you've seen and in, just for your note, Commission's pass-on guide, paragraphs 56 and 125, supplemental bundle 23, 1338, 1339. But what he doesn't do is then think through the consequences for the tiny overcharge he's found for pass-on. So, my lords, that's the context. And in the light of that, our overall points are these. First, the judge doesn't seek to satisfy the test of a direct and proximate causal link. He just never does that. And that's not a question of expression. His reasoning is based on economic theory, assumptions from incentives. Applying the economic theory and incentives he relies on also depends on other assumptions, which he has no basis to make. His assumptions are driven by an assumption that firms wanted to maintain their margin, but that is incapable of distinguishing between price pass-on and cost reduction, and so can't prove a direct proximate causal link to price pass-on. Next, his actual factual findings as to behaviour, which I'll come on to briefly, contradict pass-on wherever he makes a factual finding. He made findings as to psychological pricing, the variability of the claimant's margins in response to costs, which all contradict price pass-on. Seventh, he identified no facts that made good a direct and proximate causal link. Eighth, on extended warranties, he misunderstood the significance of that factor due to errors and logical confusions, but even there he accepted that pass-on may be disincentivized by warranties, and that in itself contradicts a direct and proximate causal link. I'll come back to that. And ninth, and decisively, none of his reasoning applies to a very small overcharge. That's here. So, with that in mind, let's go through his reasoning in the judgment. So the essential case put, if you go to 210, is based on economic theory. Propositions as to pass-on tending to be high in certain situations. That's the case put. Then I'll come back to the specific factual case that's made, which is very, very limited. On psychological pricing, first of all, 201, the judge accepts that Granville extensively adopted a pricing strategy around psychological pricing points, and he refers to our schedule and doesn't accept we got every price right. This is Annex 1 to our closing, but even taking account of those differences, it shows in the majority of cases Granville used the technique. Now, he doesn't identify a number. This is not 49%. He doesn't identify a number where it's not used. He says extensively in a majority. Then, on to extended warranties. The point here is that if you, let's imagine you're selling your computers at a limited profit margin, but you are able, in a number of cases, to persuade the customer to buy an extended warranty, on which you make a very, very large margin. You are then disincentivized from increasing the price of the package if that might imperil your warranty sales, because in those cases, any extra advantage you get from putting £5 onto the price of your package is completely lost if you lose a few warranty sales. That's the intuition which Dr. Van der Laan spoke. Now, on this, the judge accepted that Granville made extended warranty sales at high margins. That's paragraph 206. He then downplayed that, 237, saying that there was no evidence of the proportion of the package sales that generated warranty sales. But actually there was evidence. We put that in our skeleton at 70D. He also seemed to thought that 10% of total revenues on margins was not significant. But these are products with margins at 80 to 90% on his findings. And so if they're only 10% of revenue, they're a very large share of margin overall. And we put calculations on that in our letter of the 19th of January. So there was a very strong incentive, and he simply failed to consider the evidence and indeed the mathematical consequences of his own findings of 10% of revenue and an 80% margin.
Sorry.
The workings, sorry,
Yes.
you go first.
No.
The workings that you refer to in your letter of the 19th of January, was that material which was before the judge?
The underlying points were all before the judge. We didn't do the calculation because it seemed to be obvious that when you looked at the basic points, this is a massive effect. It's the first point we have a criticism that you haven't done a calculation is in his judgment.
So just slightly take issue with the idea that any calculation is obvious when you've got so many different figures.
But we say it is common sense that if you've got 10% of revenues being warranties, on 80% margins for the warranties, that the warranties are going to give you a pretty big incentive to sell the warranties.
Sorry, I'm a bit more basic. Where's the letter of the 19th of January?
Which we
These
sent-
calculations?
Which we sent to the court. It's not, I mean, not been bundled. We identified an error in our skeleton where we said over 50%, and we recalculated that to 32%, and we sent a letter to the court to correct that on the 19th of January.
Okay, that may not have made it. Did it go to my clerk, or did it go just to a central email?
To a central email, I think. But we'll reproduce it. But we're happy
I
to.
did see it, but I'm afraid that letters that come in on the
No.
morning of the case are not necessarily going to be read.
We're happy to work with the 50% figure in our skeleton. It was more about accuracy so that we're not misleading the court.
I'm just struggling at the moment. I'm not sure that I can find the reference to the 10% figure in your closing submissions.
In our closing submissions,
Yes, I mean, you say it should have been blisteringly obvious to the judge from the 10% figure.
it's in the judgment. 237.
Right. Okay. Where is it?
237 towards the bottom.
237.
The information available shows that only 10% of Granville's overall revenues were generated by warranty sales, and circa 80% margin was achieved on such sales. And it just simply stands to reason that you're going to have a massive incentive when you look at those figures. Now, the judge then at 238,
And that would suggest that 8 to 9% of revenues are profit arising from warranty sales. Isn't it?
yes, your total revenue, yes. And of course, they're not making 100% profit on everything else.
I mean, less any loss if they're making any loss
Yeah.
on the actual computers in order to.
Yeah, and they're making much lower margin on the package.
Okay. Could somebody please recirculate the letter of the 19th? Because
We will.
at the moment, all I think I saw on the 19th was a request for transcribers.
We will. Then,
Well, just tell us in the skeleton
Yes.
what is the figure we need to correct. And then
it's
we can
50
now.
and it becomes 32.
Sorry, we're at paragraph
39.
32?
It's paragraph footnote 21 to the skeleton.
Sorry, but I do have the letter of the 19th. This is the one that
Yeah.
deals with the amendments to the draft judgment.
And then a bit below.
It is the same. It is the same one that deals with the corrections of the draft.
Okay,
It's
right.
the paragraph. The next section is skeleton.
So what you want us to correct is the 50% figure on page 24 of your skeleton, page 45 of
That's
the
right.
bundle, which instead of saying 50% should say
39.
39.
Now,
Thank you.
the judge also downplayed warranties because of another error. He said at 237 that in reality there's no evidence that increasing prices would affect the volume of sales of extended warranties other than if the effect of increasing prices would reduce sales volumes. But that is precisely the point. The point is that increasing sales volumes, increasing prices will reduce package sales and with them warranty sales. That is precisely the problem. Despite all those errors, we then get to 238, and even then, the judge says, the best that can be said at this point is that the firm in position of claimants may be disincentivized from passing on some or all of a market-wide increase. So he accepts that that's possible. And again, that just defeats a direct and proximate causal link. Now, very briefly, what then were the concrete facts that Mr. Parker relied on and the judge referred to? The first were the so-called price generators, which you find at paragraph 197. And Mr. Parker said those showed a cost-plus approach to pricing. But firstly, if you look at 215, those only apply in the commercial and educational sectors, which are about 2 to 8% of Granville's business. They're not operating in the general bit of Granville's business. That's the first point. And secondly, when it goes back to 197, the judge disagreed with Mr. Parker and said that these documents don't evidence potential sales. So you find his conclusion to 215. In any event, the price generated documents do not evidence sales at the price set out in the documents. I agree with the proposition that price generated documents do not evidence sales. As Mr. Augustin observes, it suggests that Granville underwent pricing negotiations with the customer's potential sale, as opposed to a computational method, including all component costs plus a fixed margin. So the price generators did not evidence cost plus. That's the first point, and anyway, we're in a tiny sector of the market. The second bit of actual evidence was the bills of material documents, which you find at 217 onwards, and they're discussed. You find an example of them, and you see Mr. Parker's opinions, they support his conclusion of downstream pass-on. He maintains they show prices, this is 218, were set on a cost-plus basis, and then the judge disagrees. I don't see that effect of these documents. As I see it, the document could equally have been prepared by specifying a selling price and then working out the margin when certain parts of a certain specification were incorporated in the package. This is more probably what was happening because there's no fixed margin identified in the documents, and then you see there's a massive range of margins. And the point about the range of margins is it negatives pass on, because if you are keeping your prices as they are, just varying, or as they would be for commercial reasons in terms of outward sales, you're just varying your margins, then you're not passing on. You're reducing your profit because of the increase. Or at least when you have variation margins, that negatives a proof of a direct and proximate causal link through to pass on. You can't show in a particular case where margins are varying that there's been pass on. So that fact of 219 is decisive.
So you say that of these two categories which were relied on as positively demonstrated, pass on, in fact the judge's findings negative that.
Yes.
They may or they may not, and you say that's not good enough.
That's not good enough for the test. For the test. Indeed, you get on these points to 225. I do not consider it to be safe that conclusion B of material level of pass-on is 100%. While it shows a high correlation between selling price and cost, it says nothing about whether the pass-on will be 10% or 100%. Now, the judge did suggest at 233 and 242 that the bills and materials indicate that the plaintiffs might have been adjusting packages to fit prices. You see that at the base of 233, which is on page 132, called bundle. You see passing on a market where wide variable cost increase in relation to one component does not involve merely increasing the price of the existing product, but can be as easily achieved by choosing different mixes of component parts, and in so doing sticking to a psychologically driven chosen price. But again, that's all his findings get him to. Well, they might have wanted to pass on, they could have stuck with the price, you've got varying margins, he accepts all that, but oh well, they might have reduced their prices. It's just not a direct and proximate causal link through to a pass on a price, still less in any specific case. The third chunk of evidence is at 198, and this is an internal email concerning the increase of prices. And what it shows is that in relation to a different product, DRAM chips, that worldwide memory prices, this is 118 of the core, paragraph 198, worldwide memory prices have increased over 400%, and then Granville consider this and they decide to increase their sales prices. But that is a totally different situation. We're dealing with the DRAM market, not LCD panels. We're dealing with a one-off massive increase of 400% that is perceptible. The judge says at 216 that internal email, line 3, identifies a propensity to pass on costs.
Sorry, which paragraph?
216. He says it identifies a propensity. But a propensity inferred from one totally different situation does not give you a...
Sorry, 216 is a long paragraph.
Third line, my lord. Propensity to pass on cost increases. That's what he draws from this email. But a propensity does not give you a direct approximate causal link for any particular price increased on cost in the LCD panel market, not least where they are totally different sizes. Not 400% as in DRAM, but your tiny imperceptible 1% increase. And on that 1% increase, note this, that figure is the overall overcharge over the whole cartel period. So in terms of the actual things that are happening from day to day, it's still less perceptible what's happening. So that's all that the judge had in terms of fact. And then in terms of what was the basis for his reasoning that there was pass on, we picked that up, and I'll take this quite briefly if I may. It's at paragraphs 227 onwards. And 227, he says, I'm satisfied in the circumstances of this case that economic theory, set out by Mr. Parker, points strongly toward it being more probable than not that claims management sought to pass on such cost increases. And he refers back to the theoretical points made before. But if that were right, you could assume pass on in any case. And it assumes away all the possible contrary factors. It assumes also that products were not differentiated. But at 239, the judge accepts that there was differentiation, although he then disregards this in the bottom of 239, saying that differentiation was limited and primarily focused on persuading customers that by buying from the claimant they were getting a package of similar functionality. The judge's reason also fundamentally driven by a perception the claimants would want to, indeed had to, pass on because margins were tight. He says this in a number of points. Paragraph 229. It's, in my judgment, probable that margins were tight throughout the relevant period. That's in the middle of this long paragraph. And there's a number of other points where he says this. But we've given you the figures on margin in our skeleton, and in the letter of yesterday corrected. The figures in our skeleton were derived from Mr. Parker's evidence. Margins were 12 to 19%. That's Mr. Parker's own evidence. The letter gives a 15.5 figure, which is materially the same. So you can't just say, well, margins were tight. He's not identified the actual figures, he's not focused on the figures, and crucially, he's not said, okay, here's the margin figures, here's the tiny overcharge that results from my overcharge findings. This is a significant overcharge relative to the margin. He's not in any way said that a margin of 12 to 19% is tight compared to a 1% overcharge imperceptibly varying over time. So The judge's conclusion, therefore, depends on a series of assumptions all driven by theory. The factual evidence he identifies at each point comes nowhere near to identifying a direct and proximate causal link. Indeed, the actual concrete elements at each stage contradict a direct and proximate causal link. He has, for example, not shown that there would be a direct and proximate causal link in any of the majority of cases where there's psychological pricing. That in itself contradicts 65%. He's not shown there's a direct proximate causal link, although he accepts that the claimants may be disincentivized from pass-on by warranties. He's not shown that in the context of this overcharge, the margins were in any way tight, forcing you to pass on. And decisively, he's not stood back at the end of his judgment and factored together the two halves of it. He's not said, oh, well, my overcharge is this. That's actually really quite small. Can I, given that, identify a direct and proximate causal link? So if you look at the factors in Royal Mail, they militate against pass-on. No knowledge, no significant size. There's no claims by purchasers. You just have an assumption from economic theory that people would want to pass on, irrespective of the factual findings in this market. The judge was speculating, he thought it was, well, quite likely I might think there might be some pass-on here. He has not identified a direct and proximate causal link, still less one arising out of the transaction in the Westinghouse sense. And finally, my lords, I've already made this point, it's plain his assessments were driven by ASDA. When you get to 246, 247, his starting point of 50, he didn't have a basis for that, but even with it, he's being influenced by ASDA against the claims. So, well, for those reasons, we submit that no case of downstream pass-on is made out. The final point before I sit down is this. I was asked a question yesterday as to whether we had run the absolute level change point below and whether it had been put to Mr. Parker. I said I thought it had. It hadn't been a point raised before, which is why the material isn't in abundance. We've checked. Yes, we did argue it both in closing and we did put it to Mr. Parker in cross-examination. We've got a little clip of the relevant passages which we can hand up if required.
Remind me, sorry, what is the point that you...
So you remember there was the model which had, Mr. Parker had the change in semiconductor billing prices, and Dr. Van Glaan ran a sensitivity saying, well, if you just look at the average, which is not a change, that produces a total figure. My Lord Justice Snowden said, well, did you run that below?
I think
It was really you. The court put to me, was that run below? And it hadn't been complained of before, so the material isn't in the bundle, but we've been and checked. It's clearly there in our closing and in cross, and we can hand up that material if required. We've got a little bit.
Right. All right, well, we'll hear what Mr. Booth says about that.
Indeed.
well, if we could have those documents, just in case there's anything you want to say on it for me, but I take it from the last submissions on pass-on, you don't want to venture any further alternative number. If we were against you on the pass-on point, it's a 0 or it's 0.
Very, very briefly, you'll see that this is all a question of factors. So we would say that there's no direct and proximate causal link, that if you looked at the factors and give them their proper significance, you can't get to his starting point of 50 at all. That's why it's quite a nested submission. But if you assume against me that I'm wrong on everything else, every other point, then I suppose the conclusion would be that ASDA has taken him from 50 to 65. If, on the other hand, I'm right on some of my other points, what ASDA is doing is just generally on each point forcing him upwards. And that explains, for example, his scepticism about psychological pricing. And let's take it very briefly. At each point, let's take the may be disincentivized. So he's got no basis to get a direct and proximate causal link there, unless he's speculating. And what he's doing in that speculation is relying on ASDA against us. Lords, I'm grateful for your indulgence.
Yes, thank you very much, Mr. Raphael.
Grateful My Lady, my Lords, I'm going to do the 3 grounds of appeal in the order in which I address them in my skeletons. I'm going to start with overcharge, round 2. I'm next going to deal with downstream pass-on, round 3, and then I'm going to end with dealing with the ASDA proposition under compensation, round 1. If I can then turn to overcharge, I'll take my submissions in 3 stages, if I may. Firstly, I'm going to make some points on the nature of the challenge under ground 2 and the standard of review that applies to it. Secondly, I'm going to show the court the points that were emphasized by the experts at the trial in relation to modelling the overcharge and how those translate to the judgment. And thirdly, I'm going to turn to address the detail of the specific grounds of appeal, ground 2A, 2B, and 2C. So if I start then with the nature of ground 2 and the standard of review, I'll make the following points on the nature of the ground. Firstly, the challenge is to a factual determination of the judge in relation to the amount of the overcharge. Secondly, the judge's conclusion was clearly based on the evaluation of technical expert evidence. Thirdly, oral evidence was clearly important to the resolution of the disputes between the experts. That's evident from the many citations of passages of cross-examination in the judgment. Fourthly, the judge's conclusions on the relevant issues which are disputed under ground 2 were supported by the expert evidence of Mr. Parker, and the judge indicated that in general he preferred the evidence of Mr. Parker on those relevant disputed issues. Just for your note, the judgment references are paragraph 47, which is core bundle, tab 5, page 69, and judgment paragraph 117, which is core bundle, tab 5, page 93. And the judge also confirmed that position in his decision refusing permission to appeal. So that's paragraph 28 of that subsequent permission to appeal judgment, and it's core bundle, tab 6, pages 180, and it goes over to 181. But I'm just making the headline point for the time being. My 5th point on the nature of the challenge under ground 2 is that the grounds of appeal bring a telescopic focus on points which are not emphasized before the judge. And that will become evident in particular when we turn to ground 2B. And just for your note again, in the permission to appeal refusal at paragraph 27, which you'll find at core bundle 6, page 180, the judge complained that the grounds of appeal appeared to be based on an ex post facto review, relying on points that were not emphasized at the trial. Sixthly, and finally, on the nature of the ground of challenge, the claimants appear to seek a varied order from this court, under which the Court of Appeal would itself specify the amount of the overcharge. The court is being asked in substance to redetermine the amount of the overcharge in circumstances where it will not see and will not have heard all of the evidence that's relevant to that issue. Now, my lords,
I appreciate you saying that that's a reason why we shouldn't go there at all, but at some point, perhaps you could tell us what you say we should do if we do conclude that there is force in some or any of Mr. Raphael's points.
Certainly, my lord. I'll address the consequences of what relief might be in the event that the court finds one or other error. In the circumstances I've identified, given the nature of the ground of appeal, the cases urge an appellate court to exercise the utmost caution in entertaining a ground of appeal. Mr. Raphael said in his submissions that nothing much turns on the cases on standard of review. We take a different position on that issue. The court will be familiar with the cases on standard of review, but if I may, I just want to identify some passages which are of significance to the determination of ground 2. Can I start with Volpe and Volpe? That's Authorities tab 18, and it starts at page 1063.
Which volume is that, do you know?
I don't have a set in the same form as yourself, my lord, but it may be volume 3.
Yes, it does seem to be. Thank you.
Just get there myself. And if I can just ask the court, please, to turn to paragraph 2, where Lord Justice Lewison summarises the principles that apply in relation to appeals against a pure question of fact. We have the general test that the appeal court should not interfere unless it is satisfied that the judge was plainly wrong. What does plainly...
That's talking about pure questions of fact, primary facts. The question of the amount of the overcharge is not really a primary fact or a pure question of fact in the same way, is it?
It may not be...
It's an evaluative sort of... the judge is necessarily going to have to evaluate a lot of evidence and reach a determination. It's not as if the judge is, for example, evaluating whether a document was forged or not.
That's correct, my lord. The distinction between a question of primary fact and a question of fact per se, I find a little elusive. The principles that Lord Justice Lewison sets out in the succeeding paragraphs in my submission are generally applicable to questions of fact being determined by a trial judge.
He does say at paragraph 4, similar caution applies to appeals against a trial judge's evaluation of expert evidence, and then he goes on. So he seems to be drawing a distinction between what he calls pure questions of fact and evaluation of expert evidence, albeit he says similar approaches are required.
Indeed, my lord, we don't have the difference to the extent it exists being identified. But for the purpose of my submission, the points that I emphasise are the following. In deciding whether a judge has gone plainly wrong on a question of fact, what matters is whether the decision under appeal is one that no reasonable judge could have reached. So 2, subparagraph 2. An appeal court is bound, unless there is a compelling reason to the contrary, to assume that the trial judge has taken the whole of the evidence into his consideration. The mere fact that a judge does not mention a specific piece of evidence does not mean that he's overlooked it. Next. Question going to weight. The trial judge must, of course, consider all the material evidence, although it need not be discussed in his judgment. The weight which he gives to it, however, is preeminently a matter for him. And what happens, what's the test that's applied when an appeal court is looking at questions of weight? Lord Justice Lewison specifies an An appeal court can therefore set aside a judgment on the basis that the judge failed to give the evidence a balanced consideration only if the judge's conclusion was rationally insupportable. Now, as my Lord Justice Snowden has pointed out, there's an indication that similar caution applies in relation, in paragraph 4, to appeals against a trial judge's evaluation of expert evidence. And in paragraph 5, which relates to inferences, latitude is given to a tribunal of fact in relation to the inferences that the tribunal draws from the facts of the case. My Lord, just two more cases, if I may. The next I wish to take you to is the Phage case. It's Authorities tab 4, which should be in the first volume that each of you have, and it starts at page 83.
There are very few appeals in which no reference to this case is made at all.
Yes, my Lord. I'm not going to break that trend, I'm afraid. If we can turn to the well-known statements are in paragraph 114, but I want to also focus on paragraph 115, which is page 122 of the hard copy bundle. It may be in 123 of the electronic versions. And Lord Justice Lewison says this: it's important to have in mind the role of a judgment given after trial. The primary function of a first instance judge is to find the facts and identify the crucial legal points and to advance reasons for deciding them in a particular way. He should give his reasons in sufficient detail to show the parties, and if needs be the Court of Appeal, the principles on which he has acted and the reasons that have led him to his decision. They need not be elaborate. There is no duty on a judge in giving his reasons to deal with every argument presented by counsel in support of his case. His function is to reach conclusions and give reasons to support his view, not spell out every matter as if summing up to a jury, nor need he deal at any length with matters that are not disputed. It is sufficient if what he says shows the basis on which he has acted. So you don't need to deal with every point, you just need to explain why you've reached the decision you have. Final case that I want to show the court, this should be in the same bundle, it's tab 2, the Thompson and Christie case. And this was a professional negligence case concerning an opinion as to the provenance of certain antiques. Lord Justice may make some observations on appeals concerning disputed expert evidence. If I can ask the court please to turn up page 61 and start at paragraph 140. So it's right to observe that the statements that Lord Justice May goes on to make in 141 and 142 are obiter, because he states, my view about the measure of damages also means that the metallurgical evidence and any decision as to date which takes account of it has no bearing on any issue in the cross appeal. I shall nevertheless deal with matters briefly because considerable time was spent on them, because general considerations relevant to them are also relevant to other parts of the appeal. The judge then goes on to address the issue of how an appeal court should address challenges where the judge's findings are based on hearing contested expert evidence. Passages which I emphasise are as follows. 6 lines down. It is commonplace that this court will only rarely disturb a judge's finding of fact reached after hearing oral evidence whose credibility is in issue. It may sometimes be somewhat less difficult to depart from an evaluative judgment of expert evidence if the evidence is mainly in writing and its evaluation and intellectual process largely unaffected by personal credibility. The judge's factual conclusion that the vases were made in the 18th century was a composite amalgam of a large number of particular judgments where an assessment of weight and persuasiveness of each of the experts as witnesses was of critical importance. Just at the bottom of that page, his conclusions are in each instance supported by credible evidence. The existence of other evidence does not render these judgments wrong, nor does it persuade me that he should have reached an opposite conclusion. Restating evidence and submissions which the judge rejected does not persuade me that the judge was wrong when the judge's conclusions were supported, as they were, by the opinions of Christie's experts. And then at the bottom of that paragraph, but even accepting that individual points such as these are amenable to judicial evaluation, whatever the expert opinion, no appellate court should cherry pick a few such points so as to disagree with the composite first instance decision, which, in the nature of a jigsaw, depended on the interlocking of a very large number of individual pieces, each the subject of oral expert evidence, which the appellate court has not heard. And he goes on in the next paragraph, 142, to identify the type of test he is applying. He goes on to consider, he says he's not going to deal with all of the submissions, but he's going to address two matters which form part of the judge's evaluation to provide a representative examples of the approach to take. And he says this: the purpose of this is to demonstrate that the judge's conclusions were persuasive or at the very least tenable, which is the standard that he's applying, and that they were supported by evidence which he was entitled to regard as credible. So that is the nature of the standard that's being applied. And we see it being applied at 146 on the next page, where he's dealing with the first of these examples. The first two sentences: the judge's decision here is plainly supported by evidence, i.e. the evidence of one of the experts. It was not merely tenable, again the standard being applied, but in my view persuasive. So when one's dealing with competing expert evidence, it will usually be sufficient to show that the judge's view is tenable, and because it was supported by the expert evidence of one or other side, which he was entitled to regard as credible. Now, my Lord, with that, that's dealt with the first section of my submissions on ground 2, which is the nature of the ground of appeal and the standard of review. I'm now going to turn to the expert evidence before the judge, what was emphasised and how it's reflected in the judgment. I make the following points. Before the judge, on the question of the overcharge, Dr. van der Laan's position for the claimants who bore the burden of proving overcharge was that the court should adopt his price trend line model to estimate the overcharge. He maintained that position throughout the trial, and his position was that the court should not use any form of regression modelling in preference to his price trend line model. And just some references for your note for that. Judgment paragraph 63, which is core bundle, tab 5, page 76. Judge says, notwithstanding his acceptance that the method he had used was not perfect in the joint statement, he maintained his position that the overcharge should be assessed at no lower than 71%, and that's the result produced by the price trend line model. And similarly, in the petition to appeal judgment at paragraph 29, for which the reference is core bundle, tab 6, page 181, Dr. van der Laan had refused to accept that multiple regression analysis was the correct way of proceeding. So that's Dr. van der Laan's position to begin with. Mr. Parker's position, on the other hand, even though my clients did not bear the burden of proof on overcharge, was to develop a regression model from first principles. And in simple summary, it was a before, during, and after regression model. And it sought to control all the main variables, which in his expert judgment were likely to affect the price of LCD panels in the counterfactual. So those included costs, supply, demand, and the characteristics of the panels. So he conducts separate regressions for monitors, notebooks. In coming to that approach, in his first report, he had already conducted numerous sensitivities before fixing on his baseline model. Now, Dr. van der Laan responded to Mr. Parker's regression model and made some observations despite not accepting that a regression model should be used to estimate the overcharge in this case. There are two variations that are of significance. The first is what came to be known as the amended Parker model, which was set out in Dr. van der Laan's second report. And that made two relevant changes to Mr. Parker's baseline model. The first relevant change was to use an alternative demand indicator. So, as the court has heard, Mr. Parker used semiconductor billings in his baseline model. And he arrived at that choice after already considering GDP growth and business confidence. But what Dr. van der Laan was suggesting in the amended Parker model as the first change was that GDP growth and business confidence should be used instead of semiconductor billings as the proxy for the demand. The second relevant change that that model made was to include 1 month lags for each of the explanatory variables in addition to including the current variables. So that's the amended Parker model. It emerges in Dr. van der Laan's second report, and it's the first of the variations that attracted some significance at trial. The second variation that became prominent at trial was Dr. van der Laan's main price lag model. So this emerged in Dr. van der Laan's third report, and I believe Mr. Raphael showed you it during the course of his submissions. So this is a model which varies Mr. Parker's baseline as follows. It introduces as additional explanatory variables lagged prices for periods of 2 or 3 months. So it's 2 months in respect of monitors, if I recall correctly, and 3 months in respect of notebooks.
When you say lagged prices of what?
So of LCD panels, my lord. So this is
some point, you don't do it now, but at some point, I for one, would quite like to try and understand why the introduction of lagged variables, explanatory variables, creates such a difference in the amount of the overcharge just in non-econometric language.
We will try to do that.
If that's possible.
We will certainly endeavour to do that. The submission I make for the time being is that those are the two adjusted models that Dr. van der Laan identified, which became prominent at trial. And I'm going to show you how and why. At the trial itself, the aid memoir document was handed up. So we hadn't seen it before the trial. But Dr. van der Laan spoke to it in his oral evidence. He addressed it in examination in chief. And I also asked him some questions about it in cross-examination. And I want to show you what he said about the aid memoir.
It was handed up at the beginning of his cross-examination or at some earlier stage?
No, I think it was an earlier. I don't recall the specific details, my lord. It was. We certainly had it before Dr. van der Laan commenced his examination in chief, but he spoke to it and introduced it in evidence during the course of his examination.
Yep, thank you.
My lord, I'm going to have to take you to some of the transcripts. So what I'm after is supplemental bundle tab 39, page 1550.
Seems to be in volume 4. Thank you.
Grateful, my lord. And you'll see there are quadrants in the transcript. We're looking at the bottom right-hand quadrant, page 72. And you'll see at line 18, Mr. Raphael states, "You prepared this document. Can you just tell us what it is and how it works?" I've produced this table to hopefully provide some clarity on the various models and sensitivity tests that have been done by me. It's not a complete overview. There are some more sensitivity tests in here. But I think this will provide a good overview of how various models work and the variation of the models tie in together. As I said, this is all starting on Mr. Parker's baseline model and the variations thereof, so that doesn't agree that I agree with this model or that I agree with its conclusions, but merely setting out the tests that I and Mr. Parker have done. That's a little bit cryptic to follow, but the point that Dr. van der Laan is making is the fact that the model has been included in the aid memoir doesn't mean that he agrees with it being used. Second passage that I need to take you from examination in chief is at page 77 of the transcript. So this is page 1552 of the bundle. And if we start at line 11, and if I can ask the court to read line 11 to line 15. On 1552 of the bundle. So there, Dr. van der Laan appeared to be indicating, he said, well, I think if a model should be presented, it should probably be the amended particle model. That's why I circle that one with red as well. There's two sensitivities there. And you'll see if you look at the aid memoir, the amended Parker model does have a red circling around it. Now, hearing that in examination in chief, we had assumed that that was the model for which Dr. van der Laan was indicating a preference. And so I then asked him some questions about it when I cross-examined him.
And that's one which doesn't use semiconductor billings, but either of the other two.
Yeah. It doesn't use semiconductor billings. It uses either GDP or business confidence.
Yes.
And it contains 1 month lag to the explanatory variables. There were 2 changes that the amended Parker model makes, my lord. Yes. As my lord.
And his reference to applying the model to different panel sizes, that I assume is the reference to the second and third green heading sensitivity, is it? Or something else? Because that's the only place I can see that panel size is mentioned.
That may well be right, my lord. Yes. So he's circled so he's put a red box around the amended Parker model itself. And then there's some additional sensitivities to the amended.
And 40.1 in the transcript is a typo for 14.1, I take it.
Yes, I think that must be right.
Yeah. It's a big more as well.
So if we then go to my asking questions of Dr. van der Laan, so in the next tab 40, page 1556 of the bundle, the transcript page is page 53. And can I ask the court to read from line 18 on page 53, where I asked the question, can I remind you of something you said yesterday, all the way to page 55, line 11. So I asked Dr. van der Laan whether his preference was for the amended Parker model, and his response was to say, well, I'm saying that if Mr. Parker wanted to provide a conservative estimate, he should have used the amended Parker model. And the second point he makes is that if he were asked, he thinks there should be lags in LCD prices in there. So he's referring to his price lag model that he introduced. So those are the two that are identified by Dr. van der Laan when he's asked about adjustments and his position on adjustments. Now, my lord, before I go to the judgment, there are a few other passages that I need to show you. They're not in the evidence of Dr. van der Laan, but in the evidence of Mr. Parker. So, when Mr. Parker gave his testimony in court, he set out his views on how the court should assess adjustments to a regression model. So how do you decide whether an adjustment should be made or not made? I'll just find relevant references if I may. Yes, so this will be supplementary bundle, tab 50, page 1655. And I'm going to invite the court, if I may, to read from transcript page 1117, which is top left, at line 15, all the way to page 124, line 10, which is on the next page of the bundle. And once you've done
Just
that,
to orientate ourselves, this is Mr. Parker in chief or in cross-examination?
it is in cross-examination.
Okay. On page 123, line 4, where he says, I don't think you should go into that analysis without an expectation as to what its value should be. Does he mean, from the sense of the passage as a whole, with an explanation?
Sorry, I didn't follow my lords.
He's saying, I don't think you should go into that analysis without an expectation as to what its value should be. Otherwise, you're trying to fit the model to your expectation, whereas the sense of what he's saying in the rest of the passage is the opposite.
Yes. So what he's saying, so it's clarified later at lines 23 to 25. So he's saying you shouldn't be assessing the goodness of the model, the validity of your model, depending on what the answer is on the infringement indicator. So because the value of the overcharge is the thing you're trying to ascertain through the modeling, you shouldn't be assessing the quality of your model by reference to the value of the indicator itself. In his evidence, there are 5 relevant points that he's making about how one assesses the validity of adjustment. He offers there a sort of hierarchy of considerations which, in his professional view, should be applied. The first, and he says the most important thing, is to identify the right explanatory variables based on an accurate understanding of the factors that will affect price. That's the most important point. Secondly, you consider the predictions the model is making about the relationship between the explanatory variables and price. So an illustration of that might be, is the model telling me that when costs go up, prices are coming down? Because if it's suggesting that, then I have reason to doubt it, because that relationship between the explanatory variable and price is not one that I would expect as an economist. The third point he makes, or the third point in his hierarchy, is that you might then look at the statistical significance of the explanatory variables, not the overcharge estimate, the explanatory variables. And he says, fourthly, only once you've got these higher level points in mind.
When you say statistical significance of the explanatory variables, can you just, again, unpack that a little bit in econometric speak?
So the explanatory variables have been chosen on the basis that they're the factors that you consider should be affecting price. Now, if when you run the model is suggesting that those factors might not be affecting price, so the explanatory variables are not statistically significant produced by the model, then that will give you a reason to question the operation of the model. Because his starting point is, when you put together a model, you start with a view as to the factors that are likely to affect price. And the types of factors that he identifies are common sense factors that one would expect would affect price. So that's why he says...
I'm not sure I quite follow the difference then between your second and third point. Your second point was you have to consider whether the use of the explanatory variables produces a result in terms of price that is unexpected. You gave the example of, as it were, you increase costs and price goes down. What's the difference between the statistical significance of the explanatory variables? I mean, is it just a more refined version of that?
It may be a more refined version. I think the difference is, my lord, that on the second point, the model is demonstrating a relationship, but it's the wrong relationship that's being demonstrated. So costs are going up, prices are coming down.
It's the signing of the
exactly.
price, yeah.
On statistical significance, the model is indicating that there may not be a relationship, and that it's a closely related point, but it's a different point in that the model is suggesting that factor may not be affecting price.
I thought it was to some extent a de minimis point, because if you look at the statistical significance of one of these variables and it appears to be statistically insignificant, then you have to ask yourself, do I really need this? Should I be thinking about leaving it out? That seemed to me what he was saying at the top of 121.
Yeah.
So in other words, if you use a variable that produces the right sign in relation to the effect on price, but something you expect to produce a big effect actually produces something which is de minimis, to use my expression, you might start to question whether your model is right.
Indeed, my lord. So that's quite correct. My lady's right. My lord is right. The statistical significance can be relevant in that respect, where if it's predicting a de minimis effect, you consider the implications of that result and say, well, should this factor be in there?
Yeah, it might not go fundamentally to the model. It might go to if you've got 3 explanatory variables, 2 of them are statistically significant and 1 of them isn't. You say to yourself, do I need my 3rd one?
But the overarching point is that these are assessments where one's looking at the explanatory variables. So the factors that you think are likely to cause price, have a causal relationship with price. He then goes on to deal with points 4 and 5. His 4th point is it's only once you've got these higher level points in mind should you then start comparing models using other statistical tests. So he's got a hierarchy in his mind which he's conveying to the court. And the 5th and final point is the point that was made in response to the question from my Lord Justice Mayles, where Mr. Parker says, well, you shouldn't be assessing the validity of the model based on the answer it produces for the infringement indicator, i.e. the level of the overcharge it's predicting. And the reason for that is simple, because the overcharge is the very thing you're trying to measure.
In other words, don't reverse engineer it.
Exactly so, my lord. Now, I take the court to this just so it understands that before the trial judge, the issue of how you assess the validity of the model was itself the subject of expert evidence, and Mr. Parker gave his view on it. And as we shall see, the judge accepts his view on how one addresses this issue. With that introduction to the evidence, can I then turn, if I may, to the structure of the judgment? And the judgment is in the core bundle. It's at tab 5. And I ask the court please to start at page 68 of the bundle. You'll see a subheading, econometric modelling. Now, in the paragraphs that follow, the judge is setting out a general description of the techniques that are used, but he also comes on to give his views on how one should assess the validity of a regression model. The important paragraphs for my purposes are, in the first instance, paragraphs 46 and 47. Can I ask the court to read those paragraphs, please? They're on page 69. So the court will see there that the judge has in mind the difference of opinion regarding how one should assess the validity of a model. And he reaches a conclusion. He makes clear, I should make clear, even at this stage, that I prefer Mr. Parker's approach to that adopted by Dr. van der Laan on this issue. What is Mr. Parker's approach? It's indicated in the final part of paragraph 46. Mr. Parker considered that the statistical tests were of subsidiary importance because he considered the most important thing to do when preparing a model was to ensure that all the right variables were being used in order to ensure that the exercise was, as Mr. Parker put it, economically sound. So the judge reaches a conclusion about manner of assessment based on expert evidence, which he's entitled to regard as credible.
And he did go on to deal with R squared and R Ramsey reset in some detail at 48 to 50.
He does, my lord. 48 begins with subject to that qualification. He goes on then to deal with the statistical test. And I'll show you in due course that he does actually consider R squared and other statistical matters in the course of giving his ruling on the overcharge issue. But in 48, R squared, 49 is R squared, 50 and 51 are dealing with the Ramsey reset test. And just to note at the bottom of paragraph 51, sentence beginning, whether that is, so it's 3/4 of the way down, it's page 71. So what's the consequence of a failure of the Ramsey reset test? It says, whether that is so, that the Commission's reasoning does not lead to the conclusion that in every case where a model fails the Ramsey test, its conclusion should be rejected. Whether that is so is very fact-specific, and in my judgment depends critically on the economic theory and reasoning that underlines how variables used have been identified and the proxy data used for the purposes of attempting to assess the degree to which the regression model used has been undermined as a basis for assessing the likely overcharge. So he's going back to the point, it depends on the reasoning by which you've identified the explanatory variables. So Mr. Parker's point, Ramsey reset test might show you that there may be a factor that's potentially missing, but whether that is so, whether there's actually a factor that's missing, depends on the facts of the particular case and your reasoning as to why certain explanatory factors should be taken into account. And he also in 52 makes the point that the Commission was dealing with a different model, so you can't read across from their conclusion that Mr. Parker's model should be rejected.
But he refers to them as a sense check in paragraph 49. Would I be right to think that what the judge is saying here is that you use these R squared and Ramsey reset as sense checks for a model which you primarily have to design to take into account the correct explanatory variables and which behaves in a way which, broadly speaking, is what you expect, but you don't drive the creation of a model by the R squared and Ramsey reset because you could do that artificially and then end up with a model that doesn't actually fit economic common sense.
That's absolutely right, my lord. So,
So you may do your sense checks and decide, well, yes, I think I've got the right model, even though these tests are failed.
Exactly, and that's why the hierarchy of considerations is important, because Mr. Parker's saying, and the judge is accepting, the most important thing is actually choosing the right explanatory variables. I'm not going to let the statistical tail wag the dog of the explanatory factors that should be included in the model. But my lord,
And
Lord
you'll show us where you say the judge does that sense check and comes to the same conclusion.
I can show you, my lord, if it would be convenient to look at the judge's consideration of some of the statistical tests now, before I go back to the structure of the judgment.
Well, don't go out of your course if you're going to come to that.
I will come to it. If so, I'm happy to take it either way. I'm in the court's hands.
No, as long as you do come to it, that's fine.
Thank you. I'm grateful, my lord. So here, the judge is dealing with the methodological issues, as it were. He then comes on to the substantive evidence from the overcharge, i.e. the estimation of the overcharge. You'll see on page 71 the overcharge issue, bold subheading. And over the page, 72, he deals with the first main model that he needed to deal with, which was Dr. van der Laan's price trend line model, which was the primary case of the defendants. He goes on at 55 onwards to set out some of Dr. van der Laan's reasoning and to describe his model. And you'll see a pictorial illustration of the model at page 75 of the bundle, paragraph 62 of the judgment. And it essentially just involved drawing a line using pre-infringement prices for panels. There's an exponential line that Dr. van der Laan draws into the cartel period. Now, because it's important by way of context, can I ask the court, please, to turn to page 77 of the bundle, paragraph 67, where the judge begins his list of reasons as to why he cannot accept Dr. van der Laan's position and why Mr. Parker's position is to be preferred. And I'll ask, of course, the court, if I may, just to read paragraph 67 to 79. The judge gives 7 reasons why he's rejecting Dr. van der Laan's primary position. So the court will see that there, the judge has identified very serious criticisms of Dr. van der Laan's model. He has formed a view of Dr. van der Laan's approach, which is naturally going to affect the weight he should attach to Dr. van der Laan's evidence more generally. The second point I extract from those passages is that the narrow and technical criticisms that Dr. van der Laan made of Mr. Parker's model based on statistics should be seen in a context where his position throughout the trial remained that the court should use his price trend line model as the preferred model. And as you've seen from the passages in the judge's reasoning, that's a model that makes no attempt to control for the factors that are likely to affect price in the counterfactual. I emphasize this point because for an appeal court, you only get half the picture on an appeal. You don't get a sense of the points that were live at trial and which are jettisoned, but which inevitably affect a trial judge's more general appreciation of the evidence. When set against that context, the robustness criticisms that Dr. van der Laan makes of Mr. Parker's approach are trivial in comparison to the more fundamental problems with his own primary approach. So, my lady, my lords, that's the judge dealing with Dr. van der Laan's primary model. He then turns to deal with Mr. Parker's modelling, so it's page 82.
I mean, that last point, I mean, I understand the point. Where does it go as a matter of law on appeal?
Well, my lord...
Or just as a matter of appeal? I mean, you may be right that Dr. van der Laan's position and the rejection of it was a much bigger feature for the judge, and it was rejected more categorically than the criticisms that are now made of the judge's use of Dr. Parker's model. But I'm not sure quite how that fits, other than as a sort of, dare I say, jury point.
Insofar as the court is being invited in the course of this appeal to give greater weight to Dr. van der Laan's opinion on how one approaches the reliability of models. My lord, it's a point that I make that the appeal court is not in the same position as the trial judge, and the trial judge had reasons beyond those that may be expressly stated in the judgment that affected his evaluation of, that must inevitably have affected his evaluation of the expert evidence.
Would you say it goes also to the context in which particular points were actually deployed, such as plausibility and robustness, being used essentially in that context to say prefer van der Laan over Parker, rather than as a double treble sense check by reference to every iteration produced by Mr. van der Laan?
Indeed, my lady, there's an inconsistency in the position that's being adopted at trial. So the judge actually notes this. I'll show you the passage when we get to the amended Parker model. The judge notes the inconsistency between Dr. van der Laan's position in urging caution to the court when they're assessing, when the court is assessing Mr. Parker's model. Well, don't take risks about this, include these variables. Don't take an endogeneity risk with semiconductor billings, include a more general demand indicator. And the judge is saying, well, hold on a second, you're talking about not taking risks in respect of Mr. Parker's model, but your own primary model is one that has more fundamental issues with it. But I don't put it beyond that, my lord. It's just what I'm anxious to ensure is that the court gets a broader view on actually the context of the trial, because we had 5 weeks debating all of these issues, and naturally on an appeal things narrow down to particular points, but the way in which those points were determined at trial was obviously affected by the broader canvas.
It's a sort of species of what Lord Justice Lewis called island hopping, I suspect.
Exactly so, my lord.
You're saying, well, hang on a second, just don't lose sight of the fact that the judge had to choose which continent he was on first before worrying about, which bit of grass you're standing on.
Exactly so, my lord. So the judge then sets out Mr. Parker's main model, and he then does what one would expect him to do in light of the oral evidence that has been given, which is to address the variations constituting the amended Parker model, so the first of those emphasized by Dr. van der Laan, and the price lag model, the second of those emphasized by Dr. van der Laan. And can I just show you, just as a matter of structure, how he's dealing with that? So judgment, so core bundle page 84, judgment paragraph 94. You'll see a subheading, demand variable issue. So there the judge begins his consideration of the demand variable used in the amended Parker model. So do I use semiconductor billings? Do I use the more general indicators of demand, such as GDP or business confidence? And he notes just in paragraph 94, halfway down, it is this that gives rise to the first and perhaps most important difference between Mr. Parker and Dr. van der Laan. There's quite a lot of time was spent on that issue, which is not the subject of a distinct ground of appeal on appeal before this court. So he's dealing with that first feature of the amended Parker model at 94 onwards. And if I can just show, in response to my Lord Justice Males's question about where statistical tests might be considered in the judge's reasoning. So paragraph 98, you see the R-squared figures being set out, the judge considering the changes in R-squared figures. '99, he's also having regard to R-squared, the points that were being made as a matter of statistics about the choice he should make. He doesn't, to be clear, ignore statistical tests, which is a submission that was made yesterday. And if I can ask the court to go to page 88 of the bundle, and just pick up a point I made earlier about
98 is simply comparing the three candidates for demand indicator. Semiconductor billings, GDP growth and business confidence.
That's correct. And in 99 he notes R-squared results poorer than those that apply in the original Parker model, albeit the differences are minute. He then goes on to address Dr. van der Laan's concern about the use of semiconductor billings. And the basis for the concern are 100 and 101. Over the page, at page 88, the core bundle, you'll see that the judge quotes some cross-examination on this issue of the use of semiconductor billings as a demand variable. And you'll see at the top of 89, this is an indication that Dr. van der Laan's primary approach is still influencing the judge's consideration of the points he's making in relation to regression analysis, pausing only to note the apparent inconsistency implicit in Dr. van der Laan's suggestion that he was risk-averse, given his primary and preferred method of assessing overcharge referred to above. The real point about this evidence is that it's entirely speculative. It goes on over the page.
Well, all the way down to paragraph 107 is concerned with semiconductors or one or other of the other two, and the judge plumps for semiconductors, and that is not challenged now, even though it was, once you get beyond the trend line analysis, it was the major issue at the trial. Do you go for semiconductors or one of the others?
Indeed, my lord. And that's him dealing with the first feature of the amended Parker model. You change the demand indicator.
Yes.
He then comes on, you'll see the time lag issue, and that's expressed in general terms. Paragraph 108, page 90 of the core bundle. And he introduces the issue of time lags in general terms in paragraph 108. But in paragraph 109, what he is dealing with is the second feature of the amended Parker model. That's the 1 month lag to explanatory variables. In addition to having current explanatory variables. And he gives his reasons in 109 for why he's not persuaded that that second variation is justified either. And I'll come back to those when I deal with the grounds of appeal. That's 109, dealing with the second feature of the amended Parker model. 110, first sentence shows us that he's moving on to consider a different model that Dr. van der Laan has produced. And the judge refers expressly to the third report where Dr. van der Laan moved away from the 1 month lag thesis to a 2 to 3 month lag applied to price variable alone. So he's there turning at 110 onwards to deal with the second main adjustment that Dr. van der Laan had emphasized at the trial, which was the 2 to 3 month price lag model. And he sets out his reasoning on why he's not prepared to make that adjustment between paragraphs 110 and 116. And some of that is challenged under ground 2A, and I'll be dealing with that shortly after lunch. But, my lord, 117, which is page 93 of the core bundle, that's where the analysis of the adjusted versions of the Parker baseline model ends. So the judge has dealt with amended Parker model, its two features, and the 2 to 3 month price lag model. And he's then coming on to deal at 118 with a separate point which concerns post-infringement effects and affects the quality of the data that's being used by models. And he goes on to set out points about that at 118 onwards. There's quite extensive consideration given to this issue between 118 and 142, which is page 102, the core bundle. And he reaches his final conclusion on overcharge at paragraph 143, which is page 102 of the bundle as well. I do that, I go through that exercise, my lord, just to enable the court to see why it is that the judge focuses on the issues he does, because these were the issues that were emphasized in the course of a long trial. Judge is under no obligation to deal with every variation, whether it bears the weight of expert support or not. What he's dealing with is what he fairly and properly understood to be the adjustments that were emphasized. And he gives his reasons for why he doesn't think the adjustments are right, but it's fair to note that he does make an upward adjustment to Mr. Parker's overcharge estimates to deal with a couple of points that he's identified. But that's the context in which the judge's reasoning should be seen. So that's the second section of my submissions on overcharge. I'm going to be turning next to the substantive grounds of appeal. I'm in the court's hands as to whether you'd like me to start with that now or to commence afresh after the short adjournment.
When do you expect to finish your submissions?
My lord, I hope to finish certainly by lunchtime tomorrow.
Right. Okay. Well, in that case, if you'd rather have a clean start at 2 o'clock on a new point, we'll do that.
I'm grateful.
Very good. 2 o'clock.
Court arrival able.